So welcome to this evening's keynote lecture. I'm absolutely delighted to introduce Professor Fleur Johns, who's visiting us at TLSI this year. And it's a real pleasure because we've been friends for a long time, and she's a fellow traveler, so I'm absolutely delighted that she's here with us today. So Professor Johns is Professor of Law at the University of New South Wales in Australia. She's an expert in public international law and legal theory, and she's extremely well published. She's written several books, edited several books as well, and written numerous articles, which I really urge you to read, because she writes beautifully, and I should urge us to write dangerously. And you'll soon see what she means by that, because she really pushes so many different interdisciplinary spots of collaboration and research. And so her keynote lecture today is titled Automating Judgment, Judging Automation, Human-Nonhuman Alliances in International Law and Policy. Professor Johns.
Thank you so much, Prava. Thanks for that lovely introduction, and also for having me here to witness what you and Per and Helen have pulled off. It's really quite extraordinary, and I've learned so much already from reading about your projects and talking with some of you about your projects, and it's really been a great privilege to be part for a few days of what is quite a unique space, I think, for scholarly inquiry and developing collaborative possibilities. But we're not here to talk about thanking and learning, much as it is nice to do so. We're here to talk about judging. So judging is a ubiquitous practice. We're always sorting, assessing, placing. I come to stand up here professing some authority, as Keith Arnott is in this work, a different type of authority, and you judge me. And I look out at you, and fleetingly, only part consciously, I'm judging you. This is not, however, the practice of judging on which an event dedicated to transnational lawyering and judging invites us generally to focus. Among lawyers, judging is commonly understood as a crescendo, not a baseline. That is, judgment is commonly cast as an important, momentous event, something performed by people in special costume, using special language in some special place, not a routine minute-by-minute occurrence. In this traditionally ritualised, decorous mode, legal judgment seems to evince quite clearly Carl Schmitt's claim that all significant concepts of the modern theory of the state are secularised theological concepts. This slide shows a portion of Giotto's frescoes in the Arena Chapel depicting the Last Judgment. Judging is a practice of distinction about which heteronomy, or some whiff of the otherworldly, always seems to linger, the best efforts of people like Kant and Bourdieu notwithstanding. And it is, in the international legal field where I tend to labour, a practice upon which much has been made to hang. The practice of judging affords international law what Koskaniemi has termed the blessing of adjudication. This is another depiction of the Last Judgment from a 16th century Persian illustration of the Day of Judgment. Through the proliferation of courts and tribunals on the global plane, international lawyers who hope to loosen once and for all the grip of those pesky Austinians and Benthamites with their derision for international law. In judging, international law shows itself capable of issuing sanctions and thereby becomes uncontroversially law. But let us set aside the question whether judging by courts and tribunals is a practice that we have ever fully wrested from the divine. And let's return instead to that notion of ubiquitous mundane judgment with which I opened a moment ago, the judgment between you and I, say, as an illustration. Here is Gursky's photograph of the exterior of the Westfalenhallen, or Halls of Westphalia in Dortmund, Germany. For the American legal realists of last century, this was where it was all happening, amid the daily parsing of facts, prioritisation of policies, and distinguishing of precedents. In 1930, in that delightful book, The Bramble Bush, Llewellyn instructed those new to the study of law as follows: and I quote, "This doing of something about disputes is the business of law, and the people who have the doing in charge, whether they be judges or sheriffs or clerks or jailers or lawyers, are officials of the law. What these officials do about disputes is, to my mind, the law itself." End quote. Judges here, notice, stood alongside sheriffs, clerks, jailers and lawyers. Judging and lawyering were activities in which all these figures, among others, were engaged. The positivism of formal rules found its replacement in the positivism of society. Hierarchies of rule and pretensions of deductive analysis were to be unravelled amid the rabble of regular officialdom. The social was to succeed where the formal had failed. The formalisation of judging that the legal realists helped to bring about was not, however, to signal its democratisation. Never did the distribution of legal authority across the rank and file progress very far from the courtroom steps. Yes, there was greater attentiveness to the role of lawyers judging, say, what options were available to contracting parties through strategic rereading of relevant background rules. After legal realism, this came to be understood as a lawyerly practice pivotal to the prevailing social and economic order and to prospects for its change. And yes, there have been many studies of popular law talk and citizen lawyering since the 1980s in particular. Nevertheless, the judiciary has remained for most the object of loving fascination. And the post-realist era was still not very old when Dworkin's judicial Hercules rose up from the fray and acquired a following, wresting arguments of principle from the muck of the world. This is Michelangelo's maquette of the struggle between the Roman hero Hercules and the giant Cacus, who was killed by Hercules after terrorising the Aventine Hill before the founding of Rome. Yet even in Dworkin's account, Hercules was never alone in these endeavours. This is Giambologna's later representation of Hercules with the centaur Nessus. Rarely has this mythic hero ever been depicted without some prop, a cudgel, a sword, a shield. And similarly, he's never far from an animal or some human-animal hybrid, often in close embrace as he is here. And while Dworkin makes very little of it, his judicial Hercules likewise always had implements, objects and other non-human accomplices at hand. In Law's Empire, Dworkin observed that a statute can, quote, describe a physical entity of a certain type, a document with words printed on it. In fact, despite all those jokes about lawyers changing light bulbs, we legal types tend to present ourselves as very handy with things. This is an image of a work called Controller of the Universe by the Mexican artist Damian Ortega. Never has the lawyer of the past century been far from her tools and her toolbox. Pretty much anywhere one looks, one can find practitioners and teachers of law speaking about law in these terms, speaking and writing about the intellectual, doctrinal and policy tools with which they work. This metaphor describing legal work as a matter of working with tools may be among the most pervasive legacies of American legal thought and its tradition of pragmatism. And for all that Bruno Latour and Cornelia Wichmann and others have shown us about the importance of non-human actors to the movements of legal thought and practice, files, documents, pigeonholes, labels, storage facilities, and so on, it continues to be the case that most lawyers approach inanimate things instrumentally, or as tools to aid delivery of outcomes decided more or less independently of the operation of those things. So now, finally, after these pretty pictures and these mythic heroes and my talk of tools, I come to the central point of my talk this afternoon. It is, I will endeavour to show you, becoming less and less viable or defensible to think of judging and lawyering on the global plane as a process predominantly gathered up in and steered by the hand of some group of heroic judges or lawyers deftly wielding the tools of their trade with ceremony and certainty of purpose. Also, the human and non-human entanglements at work in the lawful partitioning and ranking of the world today are not well understood, I think, by reference to the metaphor of the tool. Nor are those entanglements well grasped by insisting on the necessity of principled deliberation, judicial hunches, or any other mode of patently and primarily human judgment. The distribution of agency, authority, and responsibility that transnational lawyering and judging entail today does not revolve around humans in quite the same way or to quite the same degree as might once have been the case. Elites have, of course, at their disposal an extraordinary proportion of the globe's wealth today. According to Oxfam, 62 individuals, 53 men and 9 women, possess a wealth equal to the wealth shared by half the world's 7.4 billion people. But those 62 people are not in control any more than any other group of people. Or to be more precise, the authority wielded by humans, whatever their means, is not wielded by roots as direct or determinate as has often been presumed in accounts of the global legal system and in many accounts of lawyering and judging across the globe. It is this of which I hope to persuade you this afternoon. And I'd also like to think with you about some possible implications and approaches to the shift to which I'm alluding, because I'm still relatively early in the process of working on these themes. Now, I have elsewhere referred to this shift of which I'm speaking as one of redistribution of the sensory economy of international law. But this phrase, redistribution of the sensory economy of international law, is intended to capture both change in the way that we assemble and make facts about the world and change in the distribution of power and authority associated with doing so. However, talking about redistribution of the sensory economy of international law sounds quite esoteric. So let me instead share with you an example of the kinds of change in practice that I have in mind. A story of 2 different versions of a particular judging practice. And you can, as audiences in law schools are so good at doing, judge for yourself. For my first and most recent story of judging practice, I need to take you to the Afghan-Pakistan border. After the fall of the Taliban in 2001, large numbers of Afghan nationals started to move from refugee camps in Pakistan, where they'd been sheltering from the Taliban, back to Afghanistan. And the UNHCR was there to help them. From 1988 onwards, the UNHCR had concluded a series of agreements with Pakistan, and later with Afghanistan too, providing for the voluntary repatriation of Afghan refugees. These agreements provided for the UNHCR to offer screening, supervision, and material assistance to those returning refugees. Between 2001 and 2005, the UNHCR facilitated the return of over 3 million refugees to Afghanistan. As part of this process, the UNHCR determined that every returnee should receive transport assistance ranging from $5 to $30, depending on his or her final destination, and a UNHCR family kit with plastic tarpaulin, soap and hygiene items, as well as wheat flour from the World Food Programme. In distributing this humanitarian aid, the UNHCR initially used traditional identification methods to try to distinguish genuine first-time claimants from recyclers who presented themselves more than once to the UNHCR staff trying to claim multiple assistance packages. These methods including interviews, document and photograph checking, consultation with community members, and so on. However, the UNHCR had concerns about these methods' effectiveness and also had a vision of how the institution might operate in new ways. And so in 2002, at the UNHCR's request, commercial technology vendor BioID Technologies, in cooperation with Iridium Technologies, developed for the UNHCR a biometric registration facility and mobile registration units using iris scanning and iris recognition technology. Let me read a quote that describes how these mobile registration units worked. All centres have a network of iris recognition cameras ranging from 2 to 9 depending upon the required capacity. The individual is asked to sit down in front of one of the cameras and is briefed by the operator. A series of enrolment images are taken and sent to the server in the network. This system converts the appropriate image into an iris code, a digital representation of the information that the iris pattern contains, and checks the entire database whether that iris code matches with one already stored. If that is not the case, the individual is enrolled, the iris code stored in the database, and a customer information number is returned to that particular workstation, confirming that the enrolment has been successful. If the individual is found in the database, the system returns an alarm to the workstation with the message that a recycler has been found, and also returns the CIN number that the individual was originally enrolled with. The whole process, from the moment the person sits down, is briefed, up to the completion of enrolment, takes less than 20 seconds. End quote. From the age of 6 upwards, all returning Afghans seeking assistance from the UNHCR were required to submit, and are required to submit, to iris screening. This was made mandatory in 2007 in an agreement between Pakistan, Afghanistan and the UNHCR that replaced an earlier 2003 treaty. Now, I've already characterised this process of registering, screening and ruling out certain refugees using authority conferred by treaty as a practice of judging. But this is certainly not the kind of judging, as I said, upon which international lawyers usually dwell. Judging in this context takes more or less the form with which I opened, the kind of reciprocal, mostly unspoken judging that takes place in any encounter between humans. And so before I discuss what may be new in this practice of judging, employing iris screening, I want to talk a little bit about the non-biometric, what we might call the analogue form of this practice of judging upon human encounter. Doing so, I think, may help us grasp what is not new in this process, and thereby highlight what we already know and what we already do that might be useful in grappling with it. For judging upon human encounter has always involved drawing in material and referencing factors that remain inaccessible to the parties involved. Let's take again the example of you and I judging one another when I first walked up here. That started with some degree of body-to-body proximity and sensory exchange. I stood up here at the front of the room, at which you're seated there. You looked at me, I look at you. Almost immediately, though, each of you and I perhaps engage in some part conscious process of reverie, memory trawling, checking and categorisation of which the other party to the encounter would never be aware. You might have thought, say, Fleur. Funny name. Maybe her parents were hippies. Who were those people who used to live next door to me? Who had the kid with the funny hippie name? What was it? Sunbeam? Moonshine? What was it again? They were odd people. Their house always smelled of licorice. And so on. Now, lawyers have long recognised, most acutely since the interventions of legal realism, that this sort of unwieldy roaming through particular people's past, present, education and experience is inevitably a part of exercising legal judgment. And over the course of the 20th century, and still to this day, quite a lot of effort has been and is being dedicated to trying to understand, trying to reveal, and trying to cabin the role that is played by extraneous, implicit or undisclosed factors in legal decision-making. One can think of work on racial and gender bias in these terms, as well as work on neuroscience and the law, or emotion and the law, and so on. What is common to all these inquiries, at least in some registers of them, is a sense that the extraneous processes and factors involved are still attendant upon and articulated primarily through human deliberation, language and reasoning. They may be immensely difficult to grasp, those extraneous processes, and to manage, and their capture may involve the deployment of all sorts of non-human technologies, such as paper surveys or body cameras. And yet these extraneous factors and processes are still perceived as predominantly human and recognisable as such. The introduction of iris screening at the Afghan-Pakistan border nearly a decade ago is an example, and it has to be said at many other sites as well, is an example of a judging practice that calls that recognisability into question and manifests a significant change in the distribution of authority between the human and the non-human. This is because the extraneous process that is central to the practice of judging, or one of the extraneous processes, at work in the UNHCR's iris screening program is data mining. In order to make this point cogently, I need to take you for a very brief layperson's excursion through the mechanics of data mining. That is the kind of practice that takes place, the kind of judging that takes place, at least in part, around the cylinder marked DB on this slide. Data mining entails the computerised production of knowledge through the tracing of patterns and drawing of relationships within large stores of digital information, as you know. Typically patterns and relationships that are not otherwise apparent. It does not include control over data collection. It often deals with byproducts of other processes. Data assembled for data mining purposes may not correspond to any sampling plan or experimental design, and this is certainly the case in the UNHCR program, in which data collection, that is the extracting and processing of data from images taken of people's irises, is conducted at multiple sites at rates contingent on refugee flows. Data mining, as you know, also employs algorithms. Algorithms are well-defined computational procedures that take some value or set of values as input and produce some value or set of values as output through a sequence of computational steps that transform the input into the output. They're often described by analogy to recipes. Machine learning algorithms, again, as you no doubt know, which some forms of data mining employ, are those with capacity to modify their processing operations autonomously on the basis of newly acquired information, to learn from the processing of data how to modify their own recipe and thereby refine the outputs that they generate. The concern of data mining algorithms is the extraction of interesting, that is, in the computer science literature, non-trivial, implicit, previously unknown and potentially useful information or patterns from data in large databases, however those data may be assembled or structured. And the scope of what might potentially be useful in this context need not be determined a priori. That is, it is often the process of data mining itself that identifies the patterns that merit interest and inquiry. Crucially for our purposes, data mining that employs machine learning may take supervised or unsupervised forms, or semi-supervised hybrids of the two. And each of these modes of knowledge production puts human and non-human actors into slightly different types of relation, as this slide illustrates. Supervised data mining proceeds from a training set of data known to have certain features, a record of past successes and failures, or pre-identified instances of the sort of phenomenon that is of interest to the human supervisor. The goal in supervised mining is for the data mining software in question to learn from its human trainer and the training set she has provided the signature of each point of interest in the training data and classify other unlabeled data according to that signature. Unsupervised data mining, on the other hand, commences without an initial model, without a hypothesis or norm from which deviation must be sought. The aim is to generate and explore regularities and anomalies, or to infer some probabilistic density in data, to create a model on that basis, and to continuously refine those inferences and the resulting model, including through after-the-fact human validation and review. Supervised learning offers a clear measure of success and failure, or degree of error, and a basis for redressing error. Learning takes place through the detection and correction of errors. Unsupervised learning offers no consistent overarching way of evaluating the validity, meaningfulness, or usefulness of inferences generated. Part of the process is continually revisiting and discarding hypotheses which the data mining practice itself will have helped to generate. Now, in the UNHCR program, the particular data mining technique used by BioID to classify and compare phase information, that is the sequence of digits representing a pattern in a set of iris images, referred to in this slide as an iris signature, has not been described publicly by either BioID or UNHCR. And while we can guess by reference to the relevant literature what type of algorithms might be used for this purpose, it's not necessary for our purposes today to go through those. What is important is to note that even if one did identify the classification technique employed, one could never accurately describe one version of the algorithm that would be used in all instances across the UNHCR program. That's because the various weightings and thresholds calculated in the course of reaching an accept or reject decision on any one iris signature will be subject to continuous refinement in their interaction with data using machine learning methods. It is also because a series of somewhat open-ended translations will have occurred, first in the process of implementing algorithmic pseudocode into actual computer programming code, and second in the way in which those coded operations are executed and distributed in and by particular machines. If we regard the iris recognition component of the UNHCR program as a black box, as it is quite common for legal scholars and others talking about technology to do these days, it is not a black box that we can open for purposes of extracting its contents, because those contents are constantly in the course of recalculation, rearrangement, and redistribution. So after a year of the UNHCR's systems operation on the Afghan-Pakistan border and the processing of just over 200,000 refugees, UNHCR reported that approximately 1,000 people trying to claim multiple assistance packages had been detected, in addition to more than 70,000 families rejected during the same period using other screening methods. These other screening methods, which were maintained alongside iris scanning, included interviewing potential returnees and examining their family photos and so on. In the midst of all this, the iris recognition system was said by the UNHCR to have performed flawlessly, despite the risk of data corruption posed by the heat and dust of Pakistan border territories with Afghanistan. According to the UNHCR, concerns that use of the technology might intimidate or raise traditional objections to women being photographed or compromise privacy proved unfounded. This was because, they said in a report on this, only the eye is seen on screen, and the code describing the iris has no link to the name, age, destination, or anything else about the refugee. According to the UNHCR, it was just the code, nothing more and nothing less, that discredited those 1,000 claimants, and did so flawlessly. Now, I hope that it's clear from this brief and inexpert tour through the UNHCR's recourse to biometrics on the Afghan-Pakistan border, and as I said, many other places too, that the practices of judging at work in the UNHCR program are distinguishable from the practices of judging in which international lawyers have traditionally been called to engage. Let me highlight in particular 3 points of difference. First, note the embeddedness and inscrutability of the parameters on the basis of which applicants for humanitarian assistance may be disentitled. Even though the algorithms in question will likely have been trained using a set of correct and false matches between batches of iris code, verified as such by humans, the precise algorithmic derivations of that training set used to identify a match would have been generated, as I said, through machine learning. As such, these are outcomes of automated inquiry rather than its predetermined starting points. They will have emerged and will continue to emerge in ways that may not always be explicable, even to those well-versed in relevant data mining techniques. As one group of data mining researchers has observed, it is often, quote, hard to explain how the system reached a decision with respect to any particular match revealed, end quote. A second related feature of data mining that is worth stressing in this context is its tendency to generate more patterns than are likely to be meaningful or useful, and hence the need for continual winnowing, culling, and trashing. Algorithms designed to find relationships in data will tend to do so regardless of whether there are any significant relationships naturally present in the data. Accordingly, data mining outputs are frequently not designed to be right or to be actionable at the outset. Rather, there is an expectation that many of the associations they will discover will be discarded. This lessens the sense of gravity and dispenses with the ceremony and definitiveness of judging. Instead, the practice becomes one of continuous, unceremonious tinkering. And what may be deemed useful and usable from time to time will depend upon the unknowable happenstance of how a particular model interacts with continuous inflows of data. A third distinguishing characteristic of data mining as a practice of judging is that it is not contingent upon calling forth subjects or objects as such. As geographer Louise Amoore has emphasised, the unit of analysis with which data mining is concerned is often not recognisable as a person. Data searches typically address a much lower or more fragmentary level of analysis, namely mathematical correlations between bits of data. In order for these mathematical correlations to be made useful and actionable, for an iris code match to rule out a particular claimant, no occasion need arise for a legal subject to be hailed before the decision is regarded as done. Remember that quote from UNHCR that I read earlier. The code describing the iris has no link to the name, age, destination, or anything else about the refugee. In other words, the generation, storage, and analysis of iris code under the rubric of the UNHCR program does not call forth a subject as such, let alone a subject with any particular qualities, needs, or propensities. The process of iris recognition does not diagnose flawed or virtuous character or capture any particular circumstances that might explain why an applicant might seek multiple assistance packages. All it occasions and makes actionable is a mathematical relationship meeting certain specified thresholds that, as I said, are continuously refined between data gleaned from one set of processed iris images and data gleaned from a second set. The imperatives generated through data mining are founded in momentary correlations between data that satisfy the confidence thresholds applied as of that instant. The broader significance of these will often be unclear. These sorts of fleeting associations to which data mining and data analysis give rise, and the relationships of proto-people and bit streams that they draw together, are not configurations to which international law is especially well attuned, to say the least. International lawyers have of late, of course, as you know, been much concerned with practices of counting and numbering and measurement. But even so, international legal judgment continues to be exercised largely with a view to associations organically and humanistically understood, rather than those constituted in the ways I've just described. Let me draw out this shift a little more by recalling how the UNHCR used to make distributive judgments before it started iris scanning. To get a handle on that pre-existing mode of judging practice and how far the UNHCR might have moved away from it in its turn to biometric registration, I need to take you on another journey through time and space. Now we move from the Afghan-Pakistan border and the past decade back to the mid-90s and to the UNHCR headquarters in Geneva, where its Division of Operational Support and Management is based. In the mid-90s, the UNHCR produced a series of manuals designed to guide those who face the challenging task of assessing refugee eligibility for humanitarian assistance in the field. One of these, published in 1997, was entitled Commodity Distribution, a Guide for Field Staff. Let's call it the 1997 Guide. It was designed as a statement of best practice drawn from the tremendous wealth of field experience built up in the UNHCR over time, to guide field workers that in the design and implementation of systems for commodity distribution, that is, to help them hand out goods to refugees. It was not on its face a highly prescriptive document, so much as a text to think with. It offered, quote, techniques and ideas based on current best practice which must be adapted to the particular circumstances of your operation. 5 features of this process of judgment contemplated and encouraged in this guide merit highlighting for our purposes, for purposes of comparison, that is, with the UNHCR program started up on the Afghan-Pakistan border about a decade later. First, the guide emphasised the direct participation of those whose eligibility for UNHCR assistance was being assessed. One of the 1997 guide's key points was that those responsible for distributing assistance must involve and inform the refugees in question. And I quote, "Refugees should be able to see the distribution process for themselves. Involve them directly. Don't let information on the distribution process come to them only through their leadership. Ensure the participation of the refugees, women and men, at all levels of the distribution process." End quote. Field workers were urged to call for volunteers from the refugees who agree to represent and organise the population, and take steps to ensure that refugees had proper representation and that representative leaders were identified, ideally by election. Any well-designed distribution system must provide a way to keep refugees continuously and directly informed, i.e. not just through the refugee leadership, the 1997 guide insisted. This was in line with an emphasis that has long been placed on direct communication and accessibility in international adjudication of many kinds. The shift in practice discernible in the UNHCR operations that I earlier described is likely to make this difficult, that sort of sustained commitment to addressee involvement. Emphasis is placed in public explanations of the UNHCR's biometric registration program on its speed and uneventfulness. According to BioID's account, from which I quoted earlier, the whole process takes less than 20 seconds. Refugee participation seems to be envisaged as passive and compliant. How can they argue now the machine can't make a mistake? A UNHCR staff person, Rifat Tajik, stated with apparent relief in a UNHCR newsletter reporting on the program. Now, the machine is, of course, not error-free, as I'm sure Tajik would acknowledge when pressed, nor are prospects for argument with this process necessarily restricted to identifying mistakes. Nonetheless, passive incuriosity seems to be the disposition encouraged by the UNHCR's iris recognition program. How can they argue now, Tajik said. Second, the UNHCR guide urged those working in the field not to individualise the intended beneficiaries of their work. Rather, individuals were to be assembled in groups and addressed and supported in some collective configuration when engaging with this international legal system. In the 1997 guide, for instance, the primary grouping was the family, as well as groupings of nationality and citizenship and other groupings of beneficiaries based, quote, in their original administrative or social structure. According to the UNHCR, UNHCR guide, the distribution system should aim to support the family only in exceptional circumstances and for short periods should the focus of assistance move from the family level to individuals within the family. Again, this is broadly consistent with the approach traditionally taken in most international courts and tribunals, where collectivised, typically state-mediated interaction with individuals is the norm. In the UNHCR's turn to biometrics, however, this orientation towards collective agency and representation seems to break down. Those who were enrolled in the UNHCR program on the Pakistan and Afghan border were still identified as Afghans and sometimes as Pashtun or Shinwari. However, the aim of the UNHCR program seemed to be, in part, to cut through the murkiness and inflexibility of group relations. Much is made by the UNHCR of the program's capacity to liberate people from the burden of family or collective obligation, as in the following quote from a UNHCR report. One woman who was turned away admitted she'd been through the process 8 times. Her husband had forced her and their 5 children to come back again and again to try and get another cash grant. She expressed her gratitude for the new technology, hoping it would make her husband give up the exhausting exercise. End quote. The precise way in which iris code matching intersects with other screening methods more attentive to group dynamics, such as interviews and family photos scrutiny, is not clear, but it appears to draw the latter to a perfunctory close in at least those 1,000 cases. According to one UNHCR report, if the test reveals that the refugee has been enrolled before and only about half of 1% are found to be recyclers, the person is refused assistance. End quote. No mention is made of cross-validation with family information or community members or the interaction with other screening methods. A third noteworthy feature of the UNHCR guide in 1997 is its insistence upon consensus building around practices of eligibility assessment. The guide cautions field workers as follows: the needs and your assessment of them will change with time. But at any given time, it is assumed that you will have reached a consensus with key partners as to what those needs are. End quote. This also entails reaching agreement around clearly defined roles for key partners. Quote, it is important to know and appreciate the roles and responsibilities of the main actors involved at various stages of commodity distribution, the guide stresses. Also emphasised in the guide is the importance of monitoring the equity of distributions made. This kind of consensus building does not, however, appear to be prioritised by the UNHCR in connection with its biometric registration operations. Indeed, as I've already observed, it may be difficult to explain and agree upon the practice of eligibility assessment once it becomes partially automated, given the nature of the processes involved. This difficulty is compounded by the non-public contractual arrangements surrounding the UNHCR's biometrics program. In public reporting, the key partners given greatest prominence are the UNHCR and the contractor BioID, with the latter responsible for the installation and management of the entire installation on a turnkey basis. The responsibilities that BioID was contracted to discharge include application development, on-site implementation and training, license management, procurement of hardware and software and supplies, as well as day-to-day management of all sites, including support, problem escalation and resolution, and implementation of warranties and supplier relations, end quote. Generic UNHCR policy requires that permanent UNHCR staff retain responsibility for effective managerial decision-making and supervision of non-staff, that is, of contractors. Nonetheless, the precise roles and responsibilities of the main actors in the UNHCR program are defined by a contract, the terms of which were never made public, although the fact of the contract being awarded and the contract prices concerned was those facts were published. A fourth feature of the style of judgment fostered by the UNHCR 1997 guide was its emphasis on decision makers knowing the refugees with whom they were called upon to engage. Experience shows, the guide instructed, that it is essential to find out specific information concerning every distinct refugee group in order to provide appropriate services efficiently. For this reason, decision makers must have specific information on the refugees, including on the population composition, gender and age, division of labour, access to and control of resources, end quote. Likewise, they must, quote, know the policy of the host government regarding refugees, including land use, type of settlement, local economy, job opportunities. All this was designed to ensure that judgment regarding the targeting of assistance could reconcile a mix of objectives. The 1997 guide cast distributive judgment as a complex and creative process. Those responsible for it were called to assume a role somewhat analogous to that which Lauterpacht famously envisaged international judges performing. Let me quote from Lauterpacht's vision of an international court. In interpreting and applying concrete legal rules, the court does not act as an automatic slot machine, totally divorced from the social and political realities of the international community. It exercises in each case a creative activity, having as its background the entirety of international law and the necessities of the international community, end quote. According to this conception of the practice of judging, as later described by Koskaniemi, the task becomes that of the pragmatic manager of conflicting interests. Everything is dependent on the judge's professional ability and good sense, and ability to manage the world order by equitable compromises. The UNHCR's recourse to biometrics, in contrast, seems to provide for a socio-technical practice of judging in quite a different register. The process of ruling applicants in or out of eligibility for humanitarian assistance has not been reduced to that of an automatic slot machine, as Lauterpacht feared. It still involves a complex mix of human and non-human interactions. Nonetheless, the UNHCR program, that is the post-2007 program, does cast human judgment in more straightforward and localised terms, with biometric registration and deduplication, quote, easing the job of refugee agency staff working at the centres, according to a UNHCR report. Back to that UNHCR representative, Rifat Tajik, described being relieved of the burdens of judgment and associated risks of inequity as follows. Previously, when we registered people, we had to recognise refugees we might have seen before. It was very hard. people would say that we are not treating refugees fairly, and you could really doubt your own judgment. This will make it much better. This referring to the biometric processing. Fifth and finally, the UNHCR 1997 guide invited a particular agonistic relationship to uncertainty. Refugee situations evolve, the guide said, and there is usually great uncertainty about numbers. Moreover, continuing to quote from the guide, the issue of population numbers is one linked to power and perspective. Decision makers may well have to organise distribution in situations of uncertainty, the guide counselled. Uncertainty shepherding judgment was, in this account, something with which decision makers should continually wrestle agonistically, yet by which they should never be paralysed. Rather, field workers were encouraged to, quote, live with uncertainty. Grappling with irresolvable differences of viewpoint was an indispensable part of the practice of judging that the 1997 guide sought to teach. The UNHCR's iris recognition program, however, seems to foster, again, quite a different disposition towards uncertainty. Uncertainty endemic to this program, reflected, say, in false rejection rates, cannot be eliminated. In fact, false rejection rates or false matches tend to be exacerbated by a range of factors, and some of these are especially likely to be prevalent among people with poor nutrition and little access to healthcare. Corneal bleaching, scarring, inflammation, and other pathologies, for example, can increase false matches according to the relevant literature. This is well acknowledged. Nonetheless, once it has been quantified and internalised within biometric registration infrastructure and practice, this uncertainty comes to appear relatively untroubling. You'll recall that the UNHCR's biometric registration units were said to have, quote, performed flawlessly despite the harsh conditions in the heat and dust of Pakistan's border territories with Afghanistan, end quote. To the extent that uncertainty is acknowledged, and it seems likely to be addressed according to a logic of technical optimisation, rather than through the thrashing out of differences of power and perspective contemplated by the 1997 guide. In these 5 ways, a major shift is discernible between the practices of distributive judging for which the UNHCR guide provided in 1997 and those instilled by the UNHCR's recourse to biometrics some 5 to 20 years later. Now, that shift is not absolute. Iris scanning continues alongside non-automated verification processes, and it remains embedded in a commodity distribution system over which UNHCR best practices and institutional know-how continue to exert influence. Nonetheless, the partial automation of this practice does appear to have implications for the way in which the creative activity of judging, according to Lauterpacht's famous characterisation, is experienced and performed. It's possible, I think, to summarise the changes that I've described as a shift away from the logic of negotiated agreement and faith in the reasonableness of the legal class towards a logic of algorithmic association and faith in data and data analysis. Those committed to an international legal order of which judges are emblematic value judicial consciousness, causal inquiry, testamentary proof, and oral advocacy. Those absorbed in practices of pattern recognition favour probabilistic inference and correlation as basis for action or decision. Both logics propagate and depend upon human-non-human alliances, as I earlier highlighted, but the logic of data analysis is far more attuned to the potency of the non-human contribution. Now, the 2 outlooks I've just caricatured are not, of course, entirely independent of one another. As data mining and related infrastructure bring about moment-by-moment gatherings across the surface of data, international law is actively engaged in maintaining many of their inputs and outputs. These inputs and outputs are both material and ideal. They range from the orbital positioning and control of satellites and the hiring and placement and conditioning of skilled labour forces to the idea of an elastic, developmentally oriented globalism in which international lawyers have long traded. All of these are preconditions to the biometric operations that I've described, preconditions that international law continues to help maintain. Nonetheless, the inscrutability and openness to chance by which automated practice of judging tend to be characterised, and the other features that I've highlighted, remain hard to square with the exacting criteria that international law typically sets for judgment and action. The two logics that I've just caricatured do not articulate very well with one another. They are, to some extent, incommensurable. In light of this incommensurability, lawyers disinclined to take serious account of the advent of automation in practices of distributive judging risk obsolescence of both skills and outlook, rather like those artists and art critics made forgettable by the rise of cubism, surrealism, and Dada. This is a work called The Art Critic by the Austrian artist and writer Raoul Hausmann, a key figure in the Berlin Dada avant-garde. Now let me be clear, as Obama is fond of saying, this is not a call to abandon all that lawyers have learned to do well to date. It is, however, a prompt to probe afresh how, where, and by what techniques authority is being distributed in global legal work. In particular, it is cause to rethink how much hope and attention has been and continues to be invested in the work of courts and judges in the global legal order. If one thinks of the practice of judging in terms of mundane distributive encounters authorised and sustained by law, day in and day out the world over, encounters such as those between the UNHCR personnel and refugees on the Afghan-Pakistan border surrounding the distribution of aid, perhaps judges and courts, while quaint and pleasing in their own way, are rather less crucial than is commonly presumed, even if their business is, for the time being, booming. But let's leave those venerable figures in the courtroom to their business and come back now to this room, the room that Per said we would learn to love to hate. And to this encounter between you and I, or rather among the whole crowd of us. What might we make of this automation of the practice of judging? How could we envisage the social, political and legal relations to which automated judging gives rise? In my few remaining minutes, let me identify a couple of routes for thinking about this that seem to me to be more or less dead ends or wrong turns, and some routes which could perhaps be more promising. And then I'd love to hear from you about your ideas or ways of grappling with these shifting politics of judging that I've just described. So one way of thinking about the scenarios I've described is to focus first and foremost on the risk of error. Here's a list from John Daugman's patent filed in 1991 for iris recognition technology, in which the bordered figure represents the acceptable error rate. In our scenario, this raises the prospect of some number of people being turned away unjustifiably as recyclers and being denied humanitarian assistance, of which they likely have very great need. So some scholars concerned about automation focus primarily on how you identify and handle the innocents who are unfairly denied or unjustly accused through a mechanism such as this. And while it is undoubtedly important to think about this, any such line of thinking leaves entirely unaddressed all that happens among those on whom the system works flawlessly. It turns attention away from precisely those political and juridical shifts that I've been emphasising. And these shifts signal quite dramatic change in the way the UNHCR, an international organisation charged with lawful authority, engages with its constituents or conducts instances of lawful address, encounter and action. They signal a decline in the centrality of legal subjectivity as a premise for claim. They signal a move away from agonism and towards synchronism in mundane practices of judging. A focus on rooting out and correcting error encourages one to lose sight of these broader shifts. A second way of thinking about these changes is mimetically, or through a focus on the automated mimicry or approximation of human judgment. Here I'm showing you an image of Michael Knowles' 1964 work called Computer Composition with Lines, which is a computer-generated drawing created by a computer that's programmed to mimic the painting Composition with Lines by Mondrian. And then there was a series of surveys in which people were asked which was the preferable one, and the majority preferred the computer-generated, which was the point of the publication. Some scholarship on the themes I've been discussing is focused first and foremost on trying to replicate in and around the automated practices in question structures and procedures on which we've long relied to ensure legal and political accountability. So in the context of the UNHCR program, for instance, one might try to design into the iris recognition process some humanoid second guessing. Or one might bolt onto it a complaints mechanism or review by an ombudsperson. Again, these type of possibilities are certainly worth exploring. But the problem with such an approach is that it disregards the element of incommensurability between what has been done in the past and what is being done now. It treats iris recognition as just another statistical method, when the prevalence of machine learning in particular makes of it something else entirely. Francis Galton, who devised the correlation coefficient in the late 19th century, referred to statistical method as an engine for converting a mob into an orderly array. But in the data mining that iris recognition entails, no such ordering of the data need ever take place. So the insertion of checks and balances cannot be a matter of some direct reconciliation between human judgment and automated judging practice. Everything hinges on the practices of mediation and translation put into motion within the socio-technical infrastructure. To develop critical thinking around these, we might need to start with at least a partially blank page. A further way of thinking about these changes is by prioritising the visibility or transparency of practices involved. Critics working in this vein either aspire to make visible what is currently unseen, that is, to open the black box. Here is Tom Friedman's 2007 sculpture, Open Black Box. Or they focus on making invisible what is currently too exposed or too widely and readily surveilled. Here is a work from a series by American artist Sterling Crispin called Data Masks, comprised of 3D printed face masks created by the reverse engineering of facial recognition and detection algorithms. The work is designed both to unveil how facial recognition software sees, and if the mask is worn, to obscure a face from being seen by that software. Yet again, I'm not saying that such an approach is wholly misguided, but I have concerns. The wrong turn that a focus on transparency makes, in my view, is that of false promise. The judging practice that I've described entails dynamic interaction between erratic data streams drawn from multiple sites, algorithmic pseudocode, or the high-level description of an intended function, actual programming code, and the human participants and physical infrastructure involved in the socio-technical operations in question. This is not a judging practice that can be read directly off computer code or grasped definitively by gaining access to the relevant algorithms. This is because one could never, as I earlier highlighted, simultaneously have access to all the data with which those are interacting in exactly the form in which they do so. A number of scholars have made this point. As Dorothy Parker famously said of the city of Los Angeles, there is no there. It is not clear exactly what one could or should be making transparent to whom or how that might be accomplished. Now, we might still wish to pursue possibilities that we have understood transparency to open up to us, possibilities for tracing and attributing responsibility, for example, and for calling out and countering domination. But we should, I think, abandon our fixation on transparency as an answer to the changes in practice that I've described. It may be more promising, I suspect, to start by thinking afresh about what we lawyers already do quite well, and that is engage in the distributed politics of language. This is a still of a video artwork by Israeli artist Mikhail Rovner, in which he projects very distant images of slowly moving lines of people. I wish I had a moving image of this because it moves continuously, onto the pages of a book. From a distance, they take on the appearance of lines of text. But the imagery is taken from videos she's taken of people waiting to cross borders in and out of Israel. Language represents, after all, unwieldy, highly dispersed exterior terrain on which we wrestle and wrangle every day, without those entanglements ever being fully transparent to us. It is not terrain that we ever colonise or control or bring within our grasp, despite our most fervent efforts of meaning, defining, intending, reasoning, and communicating. Although language doesn't have a sequential chain-like structure and isn't assembled out of practices of authentication and authorization on which consensus is maintained, language is something of a distributed ledger. And after working long and hard at it collectively, we have by now in the legal field some fairly good instincts for how power gathers and operates in language, and how it is sometimes possible to generate countervailing modes of power in the linguistic field. Monolingualism of many kinds remains rife, in law perhaps especially, but there are also vast numbers of people, such as people like you, in and around law who are highly adept at code switching, translation, ciphering and deciphering in language and languages, and who use these skills quite effectively every day. So when we approach the practices of judging that I've described emerging on the Afghan-Pakistan border and elsewhere, it might be fruitful to think of these practices as structured like a language, even if they are not fully accessible to linguistic description. And this is, of course, a riff on Lacan's famous claim that the subconscious is structured like a language. But I'm not holding up psychoanalysis as a definitive diagnostic or therapeutic tool to grapple with the puzzles I've described, nor am I advocating the textualization of everything or the understanding of all that we do as a practice of reading. What I am saying is that our engagements with and in language to date might equip us rather better than we realise to grapple with decision-making and relation-making practices that we cannot ever make fully transparent. Whether through psychoanalysis, linguistics, literary theory, anthropology, feminist theory, queer theory, post-colonial theory, or other modes of legal theoretical work, we already have a range of tactics for navigating practices of judging that we cannot subordinate to will or to reason, or trace definitively to an organic source. As Donna Haraway reminded us back in 1985 in her incredibly prescient Cyborg Manifesto, we have a range of intellectual and political resources available to us that do not depend on the necessary domination of techniques by any one organic body. Like a language, the practices of judging I've described are kinetic, dispersed, and operative only in their effects. Like a language, we might analyse and compare them syntactically, that is, by focusing less on the pinning down of any one element or agent and more on the contingent interaction of compound structures, including those both correctly and erroneously expressed. For example, we might think of the UNHCR, the treaty from which it draws authority, its contractual funding and employment relationships, and its technical capacities and infrastructure as a compound structure. We might study how that compound structure interacts, including through partially automated practices of authorization and deauthorization, with other compound structures discernible among the inhabitants of any one camp, and how those compounds tend to unbundle and rebundle in particular instances, without ever hoping to decode or master this whole terrain. And we might study all of this with the fervency and dedication that we have long devoted to judges and courtrooms. This book here, in Makarovna's work, this powerful kinetic visualization of socio-technical crossover, encounter, and obstruction under threat of violence, this is, it seems to me, the equivalent of Llewellyn's Bramblebush for today. This is, to my mind, in Llewellyn's words, the law itself. This depicts a practice of judging with which we must most urgently grapple. Thank you.